in the matter of Irani and Duchon.
May it please your Lordship, I appear on behalf of Mr. Irani. In this matter, my learned friend, Mr. Madame, appears on behalf of Mr. Duchon. My Lords, you will have seen, no doubt, that there are two applications which remain outstanding. The application of Mr. Irani, dated the 16th of August, for permission to rely on his transcripts of the evidence given in oral evidence. Permission for that to be included in the bundle of documents before the court. Mr. Duchon's application, dated 13th of August, for various documents to be included in the bundle. A witness statement of Mark Goldsmith, dated the 21st of July of 2017, and 3 joint medical reports from the psychiatric experts, pain medicine experts, and orthopaedic reports.
Right. Is there any objection to any objection either side to the other applications?
Well, as I understand it, my lords, I think we both object.
You do. Yes, well, we'll do the usual that we do in these circumstances. We will allow you both to refer to whatever you want to refer to. In our judgments, we will say which ones we will in fact take into account or not.
I'm grateful, my Lord. Would you like any reasons at this stage as to the objections, or would you prefer us to move straight to the substantive appeals?
I think we'll move straight to the substantive appeals, but before the end of the day, yes, or the end of your submissions, I think, in your opening and reply, deal with any supplementary points you want to in relation to the applications.
I'm grateful, my Lords. In which case, may I then turn to the appeal of Mr. Irani?
Yes.
And there are 2 grounds in that appeal, my Lord. And may I address you first in relation to the first ground of appeal, namely that the judge erred in making a wholly impressionistic award for future loss of earnings when there was a real alternative available to him. My Lords, you will have seen from the learned judge's judgment from the court below that he made an award of £150,000 as a Blamire Award and £30,000 as a Smith and Manchester Award, representing different elements of future loss of earnings. The judge himself reflected that that was broad brush compensation. He noted that at paragraph 56 of his judgment, which by definition means that these awards are impressionistic. There is no method to understand how the learned judge arrived at the awards. My Lords, may I take you to the Claimant's Authorities Bundle and to the case before the first tab, which is the case of Knower and the Ministry of Justice, which has a neutral citation of 2016 UKSC 9.
Yes.
My Lords, this is a case, no doubt you're familiar with it, a decision concerning whether the multiplier for future loss and fatal accidents claims should be calculated from the date of death or the date of trial. The reason that I bring it to your Lordship's attention is because the analysis of what's entailed when quantifying future loss is helpful. May I take you to paragraph 6 of the judgment first, which is at page 12 of the Authorities Bundle, and invite you to read paragraph 6. My Lords, the point that I make is that we have confirmation of what the normal approach is in personal injury claims, namely the multiplier and multiplicand approach. If we turn forward to paragraph 12, we can see what the approach was in a past era, and I would invite my lords to briefly consider paragraph 12, which is at page 13 up to 14.
Yes.
The change and when it came about between what is now the normal approach and the past approach of intuition and impression is discussed at paragraph 16 of the judgment, and the reference in particular to the landmark case of Wells and Wells and the short extra from Lord Lloyd of Berwick at paragraph 16, which is at page 15, my lords, of the authorities bundle.
This is all dealing with a multiplier.
My lords, in the context of this case, yes, it is. The point is broader in the sense that the principles that I would say, which are drawn from Wells and Wells, is that the Ogden tables should be the starting point and not a check. And although it is with primary reference to the multiplier, even the point that I intend to develop in due course, even if there is some uncertainty as the multiplicand, that doesn't justify departure from the multiplier and multiplicand approach. Well, Lords, the point that I simply make is this, that we know that the judge took an alternative to the normal approach, but we do also know that the judge indicated what he would have done had he taken the multiplier and multiplicand approach. At this stage, I take my lords to paragraph 47 of the judgment, and that's in the core bundle at page 204. The point, my lords, which you, I'm sure, already noted, is that the learned judge states explicitly what he would have done had he used the multiplier and multiplicand approach. He also identifies the reason that he didn't use that approach. He says that the particular reasons are that Mr. Irani may have been able to obtain better paid employment in India or elsewhere. So the concerns over the multiplicand in respect of that was pleaded in the schedule of loss in India, and concerns that he may go to a third country. That's consistent with the learned judge's previous discussion at paragraph 45 and 46, where he raises those very points. My lords, before turning to consider whether the learned judge was entitled to depart from the normal assessment, may I first provide some context just to ensure that there is no misunderstanding about what the learned judge meant. The position at trial, or rather the position on behalf of Mr. Irani in the schedule of loss, was that there was a 40% discount which was applied to multiplier and multiplicand approach. That can be seen in the schedule of loss at the supplementary bundle at page 36. And it's the first sentence of the page on page 36. And if we turn back to page 31, you can see the particular contingencies which I had taken into account when arriving at the 40% discount. The particular contingencies, it's right to say, and this is the context which I wish to provide to my lords, by the time of trial, various of the contingencies which had pleaded, that's paragraph 7A to 7I on 31 to 32 of the supplementary bundle, had fallen away. They were either no longer in dispute or it was agreed that it was not right in law that they should be taken into account. So that's paragraph 7A, B, D and G. That relates to Mr. Irani not being able to obtain indefinite leave to remain had the accident not occurred. It was conceded, subject to Mr. Irani proving that he lost his job by reason of his injuries, that the right or the ability to obtain indefinite leave to remain had been scuppered. It was also conceded and indeed found by the judge that there was no realistic chance of an Article 8 claim, not only because Mr. Irani doesn't have the grounds to merit an Article 8 claim, but the only reason identified by the Immigration Council instructed to provide reports in the case was an abusive reason, namely to bring an Article 8 claim in the hope that Mr. Irani might extend time in this country to 10 years, so that would open up another route to bring an application for indefinite leave to remain. In other words, not one that the courts could take into account as an unlawful basis for bringing an Article 8 claim. And that was found by the learned judge as well, or accepted by the learned judge, and indeed accepted by my learned friend. 7D related to the difference between living costs in the United Kingdom and India. Again, it was accepted that as a matter of law that ought not to be taken into account. The judge,
Why are they not taken into account?
so my lords, it's dealt with at paragraph 42 of the judgment, and it reflects. I haven't provided the case to you.
That's, but why?
Well, my lords, I deal with that in my skeleton argument for trial. I'm sorry, I'm not able to give you an immediate answer on the point.
My lords, it was a case called Al-Sarrad and the Ministry of Defence.
Yeah.
And in that case, which my learned friend found after he drafted his schedule of loss and gave to me before trial, it was clear that the economic and social circumstances in which a claimant finds himself as a result of the accident ought not to be taken into account, such as the living expenses being reduced in India. Initially, we had thought that was a good point upon citation of that case, and my learned friend pointing it out to us, we conceded.
And the relevant paragraphs in the skeleton argument for trial, my lords, I apologise for not being able to deal with it immediately upon the question, is at page 176 to 177 of the core bundle, and the paragraph numbers are 92 to 97. The final point that fell away, my lords, was that Mr. Irani, whether he'd been genuinely made redundant, it had been accepted that the redundancy was a sham, but not that it wouldn't have occurred but for the accident. My lords, I raise this point now because what was left, my lords, was a very different in terms to what was originally considered in terms of the contingencies that ought to be taken into account.
Can I just say, when each of you comes to a document which is in issue as a result of the applications, could you just mention this is one of the documents?
Yes, my lord.
Thank you.
I haven't referred to any documents.
No, I know, I'm just in advance, yes, I'm just mentioning it.
The remaining contingencies which were still to be taken into account were at 7C, 7E, 7F and 7H. 7C related to what Mr. Irani would have earned, the possibility he could have earned more than the but-for scenario, in other words, increased the award and reducing the contingency. The possibility of emigration to another country, which the judge recognised would be difficult in paragraph 40 of his judgment, but did in fact take into account in his 50% figure. the possibility of stopping work because of chronic pain. It was still the case at trial that Mr. Irani was reliant on opioid medication to deal with the pain condition, and it was unknown how he would cope once that medication had stopped. And that uncertainty would, contingency would seek to increase the award, again reduce the reduction reduce the reduction applied to the future loss of earnings calculation. And finally, at 7H, whether Mr. Irani could have found a job within 60 days if he hadn't suffered the injuries and thereby not lost the ability to bring the application for indefinite leave to remain because his employment would have been viewed as continuous employment. Again, that would have been a factor to increase the award and to decrease the percentage which ought to be taken into account for contingencies. The final factor was the vicissitudes of life, which of course is a factor in every personal injury case and in this case as well. My Lords, because the facts of the situation had changed or because the contingencies had fallen away from the time of the scheduled loss to the time of the trial, it's right that I, on behalf of Mr. Irani, didn't ask for a 40% discount by the learned judge. My submissions on this point are at page 244 of the supplemental bundle, and this is the transcript of oral submissions before the learned judge.
And is this one of the contentious documents?
No, it's not. It's not one of them. The transcript which is contentious is that of Mr. Irani.
Right, thank you.
It's paragraph F to G. The learned judge says, so what do you say the deduction should be? And I indicated it's difficult for me to say. The main driver here would be the uncertainty and the redundancy. And given that the career model has been adopted, and I refer to two cases, if you adopt a career model, then there's no significant further reduction to be made. That's the point that I'll probably return to, not on my appeal, but on the appeal of Mr. Duchon. And then I go on to say, it is something in the region of 5 to 10%. It's not very much at all. So that was the figure that was submitted to the court. That wasn't the it wasn't the case that I'd simply abandoned the position and not given any notice to my learned friend. In my written submissions to the court indicated that I would be seeking a lower percentage deduction than the 40%, and that's for your reference, my Lords, in the core bundle, page 179, and the paragraph is 111. My Lords, having explained that context, I return to the judge's finding of the 50% discount. The 50% discount then is a discount on the total figure, the total figure before any discount which I contended for. So, my Lords, if we turn again to the supplementary bundle on page 37, we can see how that plays out. At the very top of page 37 of the supplementary bundle, you can see the calculation of the multiplier multiplican times by 60% to reflect the 40% discount. To calculate what the learned judge would have awarded had he used the multiplier and multiplican method using his own figures, we times it by 50% instead of 60%, and the figure is 573,705, which is £393,705 more than he actually awarded. The difference is stark, and obviously it raises the importance of whether the learned judge was entitled to depart from the normal approach to an impressionistic approach or not. My Lords, I will consider in ground 2 of my appeal whether the 50% discount was an appropriate discount, but for the purpose of ground 1, may I now turn to the question of whether the judge was entitled to depart from the normal approach. principle which the learned judge should have applied was that impressionistic awards are to be made only where there is really no alternative, and the authority for that can be found behind tab 2 of the authorities bundle, and it's the case of Bullock and Atlas Ward Structures Limited with the neutral citation 2008 EWCA Civ 194. My Lords, if we consider paragraph 1 of the judgment at page 19 of the authorities bundle, we can see that the issue that the differently constituted version of the Court of Appeal dealt with is the exact issue which falls to be decided in this case, whether might a multiplier and multiplicand approach be jettisoned in favour of an impressionistic award. To give you, my Lords, a very brief overview of the case of Bullock, it's a case where Mr. Bullock was a paint sprayer who was allergic to epoxy resins. He suffered contact dermatitis, and for his future loss of earnings, an impressionistic award was made, and the Court of Appeal found that it ought not to have been made. A multiplier and multiplicand award should have been made. My Lords, may I invite you to read the 2 judgment paragraph from Lord Justice Keane, which is at page 24.
And the judge referred to this very passage.
He did, my Lords, and I will return to the judge's reasonings in a moment. The points that I would wish to bring to your attention are that all assessments of future loss of earnings involve a degree of uncertainty, and that mere uncertainty doesn't justify a departure from the multiplicand approach. So the second sentence in paragraph 21 is the important sentence, in that Lord Justice Keane says that judges therefore should be slow to resort to the broad brush Blamire approach unless they really have no alternative. That, my Lords, is the principle in the sentence. You'll see that Lord Justice Richards agreed with Lord Justice Keane, and if we turn back to Lord Justice Ward's judgment, at paragraph 14, he says that it's the multiplicand in this case which poses the difficulty.
So where are you looking at now?
Sorry, my Lords, it's at page 23 of the authorities bundle, and it's Lord Justice Ward's judgment. Paragraph 14, Lord Justice Ward identifies that the multiplicand is the issue of difficulty. Paragraph 15, he discusses the circumstances of the case. In paragraph 16, he recognises it's an issue fraught with uncertainty. And in paragraph 17, the first sentence of the paragraph is the operative sentence in terms of defining what the principle is. I say it's exactly the same as that expressed by Lord Justice Keane. My Lord, the point was considered in Ward and Allies Morrison Architects, which is an authority which is behind tab 3. I don't intend to take you through that authority now, simply to bring to your attention that the test at paragraph 20 of a departure from the multiplier and multiplicand approach was recognised as being only appropriate where there really is no alternative.
Which page?
That's page 31 to 32 is paragraph 20. My Lords, the answer then as to whether the judge was entitled to depart from the normal approach is that he wasn't, and that's because he was able to articulate an award using the multiplier and multiplicand approach by adopting a 50% discount. He therefore had an alternative to the impressionistic award and was wrong in law, I say, to resort to an impressionistic award. My Lords, may I return to the point raised by Lord Justice Hamblen and the reference the learned judge made to this case, which is at paragraph 44 of the judgment from the learned judge, which is at page 203 of the core bundle. My Lords, it's the second sentence of paragraph 44. In the first part of the sentence he says, while as a matter of principle I accept the Blamire approach should only be used where other methodology is not practicable, so in other words reflecting the principle that that is drawn out of Bullock. And then he goes on to say, it seems to me, to use His Honour Judge Hughes's Queen's Counsel's words in Kennedy, that there is a real risk that it will create an obviously unreal result. My Lord, the point that I make here is whether a multiplier and multiplicand award or calculation is practicable is not the same question as whether it will, in the judge's impression, create an obviously, or create a real risk of an obviously unreal result. The former is a question of practicality, the latter is a question of subjective judgment, namely the judge's impression of whether a multiplier and multiplicand award would be obviously unreal. And in my submission, only the former, the first part of the second sentence of paragraph 44, is consistent with Bullock. My Lords, if we were to deconstruct the multiplier and multiplicand into its component parts, that provides the confirmation that the calculation was practicable. In respect of the multiplier, there is no indication that the judge had any issue with the multiplier used. And in respect of the but-floor multiplicand, he says at paragraph 41 that the approach used would have been an acceptable methodology. He notes that the figures were taken from the annual survey of hours and earnings for engineering professionals, which was a occupation which closely married the profession that it was anticipated Mr. Irani would continue in and go further along. We can, my Lords, I say, reasonably infer that there was no problem with the but-for calculation from this fact that it's not one of the two issues which the learned judge below raised in paragraph 47 when he raised his concerns with the multiplier and multiplicand approach.
Are you? They've made a whole series of points there. Are you saying that no judge can come to a conclusion that applying the methodology of the multiplier multiplicand, there will nevertheless result a real risk of an obviously unreal result? Are you saying that's not possible? Or are you saying even if it's possible they can reach that conclusion as a matter of their judgment, they can't take that into account? I'm not quite sure what you're saying.
Well, my Lords, the question, the principle that I say is applicable is one of practicality. If the judge is able to determine what the multiplicand and multipliers ought to be, then the calculation is practicable. If they aren't, for example, if there is a dispute of issues and facts such that it's an impossibility to determine the component parts so that the calculation can be made, then clearly it's not practicable. There's no alternative than an impressionistic award. So it's
I'm not sure you're answering my question. I think I may be wrong about this, but I think the judge is saying, yes, there is, as a matter of principle, you should use the Blamire approach when it is practicable.
yes.
But if I were to do that, it's practicable, there's a real risk it will create an obviously unreal result. They're not the same issue, I think he's saying. And I'm asking you whether the first thing is that a possibility that applying as a matter of practicality the multiplicand approach, nonetheless the result may be obviously unreal.
No, my
Are
lord.
you saying that's not possible?
No, I think that must be the logical consequence of what I am saying. That it's not. So if the learned judge is able to take into his concerns and adapt the multiplier and multiplicand to meet his findings or her findings of fact made in the particular case, then the calculation will be practicable and there'll be no question of whether it's an obviously unreal result.
So you can't have both. You can't have a practicable application and an unreal result.
Yes, my lord, that is my point. And I will return to that point to develop that submission.
Just before you move on, Mr. Swoboda, could you help me please with your submission about paragraph 41 of the judgment?
Yes.
Because as I noted it, and forgive me if I missed
Yes.
part of what you were saying, your argument was, first of all, there's no indication anywhere in the judgment that there was any problem with the multiplier,
Yes, my lord.
and that as to the multiplicand, the judge found the figures to be acceptable and practicable.
In respect of the but-for multiplicand, I'm still to come on to address you in respect of the residual earnings multiplicand, but in respect of the but-for multiplicand, he refers to it as being an acceptable methodology. I think his exact words are...
So what he would have earned
Yes,
if there'd been no injury.
Indeed.
yeah, but isn't the key point of paragraph 41 that the judge is contrasting the availability of an evidential basis for calculating the earnings if Mr. Irani remained in the UK, and the absence of evidence as to what he would earn in India?
Well, my lords, I will come to deal with the point on evidentially whether there was sufficient evidence before the learned judge in my second round of appeal, and I can see the point that that the learned judge, my lord, that you make, that it is true that the learned judge found that he rejected the claimant's case on the residual earnings capacity as pleaded. I don't shy away from that fact. My point is not that he didn't reject it, but once rejecting it, he was still able to make adjustments and alteration to it to ameliorate his concerns.
Right. But to calculate the multiplicand
Yes.
for a future loss of earnings, put it in very very brief terms, you need the figure for what would have been earned in the pre-accident employment if that had continued,
Yes.
and you need the figure which is likely to be earned now given that the accident has occurred.
Yes.
And the first of those figures minus the second of those figures, in broad terms, is the multiplicand. But isn't the judge saying here in 41, well, I've got the first of those figures, but I haven't got the second of those figures, so I can't sensibly calculate a multiplicand?
Well, I think what the learned... So what we do know from paragraph 40 of the learned judge's judgment is that he finds as a fact that Mr. Irani will suffer a reduction in earnings if he returns to India.
Yeah.
He goes on in paragraph 41, as my lord rightly says, to contrast the position. What his assessment of the evidence in respect of the but-for multiplicand and the residual earnings multiplicand. I accept those points, my lord. but he is still unable in paragraph 47, having considered the issue further in paragraphs 45 and 46, to say what he can do to ameliorate those concerns.
All right, so your argument is that any uncertainty about the multiplicand is removed by adopting the multiplier-multiplicand approach and then discounting it as may be just to reflect those uncertainties.
And in brief, it's the better approach because it's a data-driven approach rather than a wholly impressionistic approach.
But isn't there a sliding scale that at some point the very discounting becomes what you would term impressionistic?
My lords, I can see that point as well, but the fact is the learned judge was able to make this distinction. There are cases, which my learned friend will no doubt take you to, where the learned judge is simply unable to say what the discount would have been. And if in those cases, clearly, then it is the learned judge is effectively saying, I can't work out the calculation. I know that there is a loss, so I'll make an educated guess as to the loss. But in this case, we're not at that situation. If we're at the sliding scale, we're on the right side of the line for Mr. Irani's purposes.
Yes. All right. Thank you very much.
My lords, the point that I think I probably explored already with my Lord Justice Holroyde, the residual earnings multiplicand, the learned judge was able to make the alteration to ameliorate his concerns, and that's exactly what I say he does at paragraph 47 of the judgment. He raises the concerns at 45 and 46, and indeed at 41, and then deals with it at 47. My lords, the point really is as simple as this. If all the components are identifiable for a multiplier and multiplicand calculation, then such a calculation is practicable and should be adopted. I make this point, my lord, there is somewhat of an irony that the learned judge rejected the calculable and verifiable award in favour of an impressionistic award on the basis of an impression that the multiplier and multiplicand approach might be unreal, and that's what his finding is at 44, the second part of the second sentence. It's an impression that the multiplier and multiplicand approach might be unreal. That, my lord, makes an imperfect situation worse, not better. And to give it its full context, the judge had doubt about one of the variables from the multiplier and multiplicand approach, which he was nevertheless able to deal with by adjusting the calculation. But instead of doing that, he used an approach where there must be considerable doubt about all the variables. My lords, the point that I make is it's difficult to see the logic.
He has to make a finding, doesn't he, on the balance of probabilities as to what the residual earnings figure is to be.
My lords, I don't accept that entirely as being correct, and that I think probably gets onto the issue of when a loss of a chance is appropriate. My lords, to deal with that point, there is a summary in the case of Herring, which is at tab 7 of the authorities bundle. And it's particularly paragraphs 25 and 26 that I'll draw to your Lordship's attention to at this stage. It's at page 99 and 100 of the authorities bundle. So in answer my my lord, to the inquiry as to whether it's the learned judge has to make a finding as to the residual earning capacities.
Well, he has to make a finding as to the multiplicand, does he not?
He
So he has to make a finding as to the two elements of the multiplicand.
Yes.
And he has to do that on the balance of probabilities.
Well,
He's going to make a finding.
if he's adopting the career model, then yes, I agree that that is the appropriate approach. If he says that there needs to be a departure from the career model, then that involves a loss of a chance analysis.
But that, according to this case, is where there's a chance that the career would take a particular course even significantly higher overall earnings. It's a particularly special case, is that right?
So there is a distinction here. There's where there has to be a special circumstance, and the circumstances is a point which is raised in one of my additional grounds in respect of the cross appeal. The loss of a chance approach traditionally or taken in law, where it's dealing with a counterfactual situation and the actions of a third party which would apply to the loss of earnings, which is why it's a truism that, as the Court of Appeal says in Herring, that the assessment of future loss in this field is in a broad sense the assessment of a chance, or more accurately a series of chances as to the likely future progress of remuneration. That applies just as much as to the residual earning capacity as it does to the but-for earning capacity. But my lords, I don't particularly wish to get lost on that distinction, because I broadly accept the point that the learned judge must be able to make the calculation. I don't say it's clearly preferable that the learned judge gives and identifies the figures. So, for example, if there is to be an adaptation to a multiplier, or an adaptation to a reduction factor, or an adaptation to either the but-for multiplicand or the residual earnings multiplicand, it's preferable that the learned judge says so explicitly. But the learned judge can, I submit, still take into account uncertainties by applying a broad discount, which is in fact the exact approach which I invited the learned judge to take in this case. You'll remember that I invited a 40% discount initially and then changed the position when the facts changed to a 5 to 10% discount. So I say that is an acceptable methodology, the methodology which the learned judge articulated. My lords, if we take the concerns of the residual earning capacity to an extreme position and not one which reflected the learned judge's views, a position that there was no reduction in the residual earning capacity proved, so that the only element of future loss of earnings is caused by disability or disadvantage on the open labour market. We know in this case that the learned judge did find Mr. Irani was disabled. That's a point that I'll come back to in due course. But if he had applied the multiplier and multiplicand approach on the basis that the earnings were the same for both the but-for and the residual earning capacity, but only the multiplier was adjusted to take into account disability, that would give rise to an award of £503,307. And the calculation, my lords, is set out in my skeleton argument, which is to be found at page 36 of the core bundle.
So if there'd been no paragraph 47,
Yeah.
would you have any ground of appeal?
I don't think so, no, my lord. Not in relation to the first grounds. I am reliant on the learned judge finding that he can articulate what the award would have been. But to return to the point that I make, a calculation just to reflect the disadvantage or disability would be 17 times the amount that was actually awarded for disadvantage on the basis of disadvantage. That amount is on the basis of more extreme findings from the judge. The point that I'm making, my lords, is this, that his educated guess of £30,000 for the Smiths and Manchester when compared to an actuarial approach based on data, is wholly different. Hugely different. And that is why it is only where a judge cannot calculate because of their findings of fact, where they can't reach a conclusion as to what the various components of the multiplier and multiplicand should be, that it's appropriate to take into account an impressionistic award, because an impressionistic award can be wildly wrong, at least based on actuarial data, which is the normal method for assessing personal injuries and which allows for consistency and fairness. My lords, the reason why the learned judge made the error that I say he did at paragraph 42 is clear. The reference to the words obviously unreal result from a case called Kennedy and London Ambulance Service NHS Trust, which the learned judge himself referred to in paragraph 44. My lords, that's a case which came with the neutral citation 2016 EWHC 3143 and came before Peter Hughes, Queen's Counsel, sitting as a Deputy High Court Judge. Miss Kennedy suffered carbon...
Which tab is that?
It's tab 4, my lord. Miss Kennedy suffered carbon monoxide poisoning and as a result suffered a chronic psychiatric condition and was unable to work since the date of her accident. The question which arose in that case was different to the question in Mr. Irani's case. It was whether she was disabled within the meaning of the Equality Act and whether the reduction factor, which is applied to determine the multiplier, should be altered. It was a wholly different case. My lords, may I invite you to consider paragraphs 93 to 97 of the judgment, which is at page 50 to 51 in the authorities bundle.
Sorry, we're at tab 4.
Tab 4 and it's page 50, my lord.
Extraordinary number of unreported cases.
Yes. Well, I raise this to your attention, my lords, only because the learned judge used it as expressly as the reason for coming to the conclusions that he did. My lords,
Is it? I just press you on this.
yes.
Is it necessarily inconsistent for the judge to say, well, I don't think there are so many uncertainties in relation to what sort of work Mr. Irani might get, whether in India or elsewhere in the future, what his prospects of promotion might be, and so on and so forth, that really I haven't got enough to go on in order to make a sensible assessment of future earnings. But then to say, well, if I had to apply this multiplier-multiplicand approach, that's the deduction I would have made. But to say, but that's not the appropriate course to take, because there's so much uncertainty that that would there's a real risk that it would produce something which is unreal. Why is that inconsistent? You say, well, he could have done it, but the fact that he says, well, if I'd had to do it, this is what I would have done in a very substantial discount, doesn't mean to say that he's saying that he thinks he's got enough to make an accurate assessment.
My lords, the point that I
You
made...
have to read the judgment as a whole. So, what could be said against you is that you're sort of dissecting it and taking paragraph 47 on its own, and you're reading an awful lot into it. But you have to read the judgment as a whole, all the way from 41 onwards.
My lord, I accept the point that you have to read the judgment as a whole. My point is this, that for paragraph 44, he does give the reason, and that's where he makes the error of law, because he conflates two separate points. He conflates the point about whether the calculation is practicable with whether it would create an obviously unreal result. Whether it's obviously unreal in his eyes is an impressionistic judgment. It's separate to a question of whether he can make the findings of fact which allow for the calculation to be made in the first place.
But in 46, his conclusion is that on the evidence, there's no proper basis, no evidential basis to make the finding.
He does, I accept that, but he does make an error in paragraph 46, which I'm going to address you in respect of ground 2. So I agree there is a real tension there between 46 and 47, but the fact that he is nevertheless able to articulate, one has to decide what he really meant, and given that he was able to articulate the fact there was a 50% discount, he must have meant, I've real concerns about this, but nevertheless, to take into my concerns, this is what I would do. And it's, what he would do is £393,000 more than the impressionistic approach. So is it better for him to effectively, if you'll excuse the analogy, throw the baby out with the bathwater and completely reject the whole of the multiplier and multiplicand approach? Or is it better that he simply reverts to a position where there is no idea as to how he has arrived at the figure that he has done? My lord, I hope I've dealt with the point sufficiently.
Much more, really.
There's 3 points that I want to make in respect of Kennedy, if I can ask my lords to consider that point again. that authority again. The first is this, that it's an unreported decision, but nevertheless a decision from the High Court, which clearly couldn't overrule the authority of Bullock and subsequently of Ward, so the judge should have followed Bullock and not Kennedy. The second point about Kennedy is that in Kennedy, the judge actually did undertake the multiplier and multiplicand approach, but amended the reduction factor. So this is at paragraph 101. What the learned judge in Kennedy did was to compare the multiplier and multiplicand approach with a more impressionistic award or the figures which were being submitted for a more impressionistic award, to try and come to a more reasoned conclusion. That was an approach which could have been taken by the learned judge in this case, but he didn't do that. He just went straight to an impressionistic figure. And the third point is, my lord, if Kennedy is followed, and if judges hearing trials are able to revert to an impressionistic award on the basis of their impression of an obviously unreal result, it would defeat the very purpose of the move away from impressionistic awards to more data-driven or actuarially driven awards, as was discussed by the Supreme Court in Knauer. My lords, the simple point is, if a trial judge is able to revert to an impressionistic award on the basis of impression, then what's the point of the rule in the first place? My lords, may I deal with this final point in respect of ground 1, and that's this. Was it open to the judge to make an impressionistic award in respect of disadvantage and disability, even if not in respect of the other loss of earnings? So you'll remember that the learned judge made a Smith and Manchester award of £30,000 as well as a Blamire Award of £150,000. So it's the Smith and Manchester type element that I'm taking you to, and you'll recall, my lords, the huge contrast between the figure that would be arrived at had he used a multiplier and multiplicand approach, a figure over £500,000 for disability. the answer to the question of whether he was entitled to make an impressionistic award in respect of this element of future lost earnings is no, and I say no for two reasons. The first is that Smith Awards are just as impressionistic as Blamire Awards, and there is therefore no reason in principle to distinguish between the two. It's the same actuarial data from the Ogden tables which informs the calculation of both. And as is the case for the Blamire Awards, the court should, in my submission, only resort to Smith Awards where there is really no alternative. My Lords, may I deal with the case of Billet, which comes behind tab 6 of the authorities bundle. It's Billet and the Ministry of Defence, the neutral citation, 2015 EWCA.
So how does he take into account disability? If he's applying the Ogden tables,
Yeah.
how is disability factored into that?
Into the learned judge's approach.
Well, he's done, you say, an impressionistic.
Yes.
Produce an impressionistic
Yes.
calculation in relation to disability.
Yes.
Take that into account. You say that was wrong.
Yes, I do not.
How would it otherwise be taken into account?
It's taken into account in the reduction factor, which is applied to the multiplier and multiplicand award. So, a reduction factor is applied depending on whether on three factors: the sex of the person, which takes into account mortality; the educational status of a person, which does what it says, but has three categories, and whether a person is disabled. So a disabled person, there is a much more stark reduction factor than a non-disabled person, and that reflects the actuarial data that it's much harder as a disabled person to, or it's much less unlikely as a disabled person that you'll either be in work continuously or that you will achieve such high earnings. So it's a reflection of the data of what actually happens depending on your earnings, your sex, and your whether you're disabled or not.
You still would have a base figure on which to make your discount.
A multiplicand,
Yeah.
a residual earnings multiplicand, yes, my lord.
So if you don't feel able on the evidence to arrive at a multiplicand figure, you don't get to this, do you?
No, I think that's the logical conclusion, my lord, yes. Unless you are able to say what the multiplicands should be, then you can't use this.
I think your real point here is, there was nothing in the disability element of the multiplicand which precluded the judge from reaching a figure.
Indeed.
I think that's the way you're putting it, really, aren't you?
My lords, I agree entirely that the learned judge found that that Mr. Irani was disabled, and he expressed no concerns as to that for rejecting the multiplier and multiplicand approach.
He doesn't say, I think, in his judgment, that's one of the reasons he can't apply the multiplicand approach.
Yes, that's correct. So it's 45 to 47 where he's explaining his reasons for rejecting it, and it all relates to the residual earning capacity. There's no other factor taken into account.
Well, isn't that so? I mean, as my lord has said in there, if you're wrong about the judge because of the uncertainty about the residual earnings, if you're wrong in saying that the judge is not entitled to take an impressionistic approach, this point falls away.
Yes, I accept that.
Whereas if you're right, then equally this point, it doesn't affect the matter at all because the judge didn't treat this as a reason for giving an impressionistic.
My lord, that was the second point I was going to make to you, yes.
I mean, it's as simple as that.
I agree. And the only reason that I was going to look at this in more detail is because I anticipate my learned friend will say, if you are persuaded that the multiplier and multiplicand approach should be taken, then there should be some alteration to the reduction factor. And I would urge my lords you not to take such a course, firstly because that would be to add reasons to the learned judge's reasoning, and there is no respondent's notice from my learned friend to add such reasons. And the second point that I wish to make, and this is relating to Billet, is it might be said that Billet could be considered inconsistent in respect of disability with Bullock, which deals with the Blamire Award. In Bullock, the Blamire Award is dealt with, the Smith and Manchester Award isn't. which is why I felt it necessary to address you on the point of why I say billet is consistent with the approach taken in Bullock.
Why don't you keep your fire on this to see exactly what's said by Mr. Madden?
Very well, my lords. That being the case, then, I will hold fire and move on to ground 2, because I think that addresses all of the points that I would wish to address in respect of ground 1 of the appeal. Unless, my lords, there are any issues which you would like me to address further on ground 1.
Thank you very much.
My lord, ground 2 of the appeal is that the judge was wrong to reject the claimant's case on his residual earning capacity where there was no challenge during cross-examination on his residual earning capacity. This, in other words, relates to the actual 50% discount which the learned judge did apply. And that's because the learned judge was concerned with the residual earning capacity. My lord, the principle that I submit is correct is that where there is no cross-examination on a particular issue, the evidence given by that witness ought to be taken as accepted. And I submit that that's a procedural rule of fairness. I don't say it's absolute. I concede that that there are 2 principal exceptions to the rule. Firstly, if it's an issue of minor importance, then there is no need to cross-examine. And secondly, if the testimony can be characterised of an incredible or romancing nature, then again, I would see that there is no obligation to challenge on the point. My lord, the principle is discussed in various leading texts, and if I might take my lord to tab 8 of the authorities bundle, and Pipson on evidence, the 19th edition, and particularly to paragraph 1212, which is at page 110 to 111.
So we're dealing here with a witness of fact.
Yes.
So we're concerned with challenges to evidence of fact.
The rule, I say, as I expressed it a moment ago, is set out in the first sentence of paragraph 1212. And the reason for the rule set out in the first sentence on the page 111.
It's true. It's all governed by the word "in general."
Yes.
In general. So you've got to be very careful about laying down very specific rules about this sort of issue.
My lords, well, even if you don't accept my formulation of the rule, I would say that in the circumstances of this case, the challenge was required. My lords, the principle can be traced back to the case of Brown and Dunn, which is a case from 1894, reported in an obscure set of reports called The Reports, page 67. My lords, I don't intend to take you through that case because the subsequent authorities cite the necessary passages from the case that I'd draw to your attention.
Well, but can we just be a little bit realistic? One of the main things that was relied upon by your client was a letter from somebody who didn't give evidence themselves.
Yes.
Well, so far as concerns the weight of the evidence,
Yes.
how valuable, that isn't a point to be put in cross-examination. So it's not a point which you put to witness, but that doesn't carry much weight. That's a matter for submissions.
I accept the point entirely, but that doesn't mean that if the witness says in his evidence, as this witness did, that his earnings, that he wouldn't be able to continue with the same type of field when he returned to India, and he would earn less, significantly less, when he returned to India, then those issues of fact ought to be dealt with in cross-examination.
Because we're talking about fact, he's expressing his opinion about what he thinks will happen in the future. He's not making a statement of a fact as to what has happened. Why should one have to, if he hasn't got the evidence to carry the weight of that view that he has, it's his belief, why should he be cross-examined about that?
Well, my lords, I would take issue with the point that the evidence, there wasn't the weight, it's not just the letter, but in any event, it was a part of his pleaded case, and as part of his factual evidence, that he would, as a matter of fact, earn considerably less when the rupture in his immigration
Is it a
section.
statement of belief on his part?
Yes.
That's what I'm trying to get at.
Yes.
It's a statement of belief on his part, and the burden was on him throughout to adduce evidence sufficient to establish that belief. Merely to say, well, I believe I will, doesn't really help very much. You know, he needs to get some extra evidence on that, and then if he had extra evidence, which could be was called and to which there was properly adduced as evidence, then there might be cross-examination about whether that evidence was true or false. That's why I'm saying you have to be very, very careful here. And there's a general proposition, if there is a conflict of fact, is you have to put the case to the other side's witness. But I'm just querying with your putting to you, that's not the truth, that's not the position when you're making statements about what your personal belief are. Nobody suggests he didn't hold the belief. It wasn't being, nobody was saying, well, you're lying, you don't really believe that. The question was, what weight did that belief carry?
Yes. Well, my lords, I would say that the reasoning behind this rule is that this is a point which I would seek to draw out from the question of from the authority of state and GMC, that the reasoning behind the rule is that the best way to get to the right answer is to challenge the witness on their evidence, and the evidence that forms, in the case of a party, their case. And his evidence was as set out in the schedule of loss. The fact that there was no challenge meant that the right answer couldn't be got to. And we know in this case that the learned judge actually did make a mistake, and I'll draw that out in a moment. And that was, I submit, exactly because the learned judge never had the opportunity to hear the challenge to the witness and hear what his reasons were, whether he accepted the propositions as being right or wrong, and all that goes along with it, demeanour, and whether it was a matter of speculation or not. My lords, as I said, I don't intend to refer to the case of Brown and Dunn. I can provide your lords with a summary of the facts in that case if it would be helpful, or move on to, if it's not necessary.
Well, I think that's a matter for you.
Very, very well, my lord. Well, in that case, it was a defamation action brought against a solicitor, where the genuineness of the solicitor's retainer was an issue, but never put to the witness in cross-examination that the retainer was genuine, even though they had the witnesses had given evidence in their examination in chief that the retainer was genuine. That's the context in which the relevant passages from Brown and Dunn were made. My lords, may I at this stage turn to Markham Corporation and Zypher Limited. That is behind tab 10.
Yes.
It's an intellectual property case, a case in which the judge made adverse findings against a witness, Mr. Buckby, who hadn't been challenged in cross-examination. My lords, it's paragraph 56. At paragraph 56, there's a framing of the issue, and I'd invite my lords to consider that paragraph, which is at page 152 of the authorities bundle, and it's the sentence beginning there, but there is a second ground.
So sorry, what was the paragraph?
Paragraph 56.
56.
disbelieved.
Yes.
But as my lord said, nobody was saying that your client may not have believed what he was saying his earnings would be. That's not the issue.
Well, I say that that can be used interchangeably with his evidence rejected, whether that's because of the rejection of disbelieved or some other reason, because of the purpose of the rule. My lords, the case of Markham refers to the case of Allied pastoral.
Let's just see how this would play out if you're correct.
Yes.
So if you're correct, in a case like this, where somebody, not an expert, so it's not a case of expert opinion which is being challenged by another expert, but just a layperson coming along saying, well, I believe that I could earn £100,000 in 10 years' time, or the reverse, I believe I could only earn £5,000 in 10 years' time. And there's no other evidence to support that proposition other than the statement of belief of the witness. If you're right, then the court is bound to accept that statement of belief unless it's put to them that that's not correct. So what's going to happen? So the other side is going to say, well, that's just your statement of belief. You know, you've given us no disclosure, no evidence in relation to that. How can you possibly sustain it? And then they come out with a whole series of things which are not previously indicated at all. They've spoken to this person or that person or whatever it may be. Completely new evidence which wasn't there before. And what then are they going to do about that? They're going to say it's all inadmissible? Or is it admissible? I mean, here it would presumably be based on things that he had seen on the internet, or he talked to X or Y or Z, all hearsay evidence. I mean, how practically is this actually going to work out?
Well, my lords, in the example that you gave, where there is no evidence, no disclosure, then there'd be no requirement to cross-examine, because on my formulation of the principle, it would be an incredible or romancing story, unsubstantiated. If it crosses the boundary of being more than an incredible or romancing story, then the witness ought to be challenged, because it's not a question, my lord, of if I might put it in this way, tactics, of what the other side or the other party might fear from the answer, but a question of getting to the right answer.
What is the question you say should have been put that wasn't? What is the question that
My lord,
ought to be put in cross-examination?
If I were in my learned friend's shoes and I were having to cross-examine Mr. Irani, I would have done the following. I would have questioned whether there was an automotive industry in India. That Mr. Irani's case, as is evidenced, is that he had very niche qualifications, which means that he works in research and development in the automotive industry. So I would have, on the basis of research which I'd have already undertaken, questioned on that subject. I would have questioned on whether his skills were transferable, his skills on the basis that if there is no automotive industry in India, then the skills that he had may have meant that he could have gone into a different industry and earned a higher amount than he said was possible.
These are all statements of belief.
No, well,
These aren't statements of fact. They're all about what he believes to be the case.
Well, my lord, I would have suggested to him that on the basis of research, if I could identify it to be correct, and indeed perhaps having a shadow expert to help me to identify the issues, would have cross-examined on not just a statement of belief, but a statement of fact of whether there is a particular automotive industry in X state in India, or whether in fact the skills that he obtains were and are attractive to others in other industries, or where and how he might have gone to third countries. So, for example, there's no challenge to the proposition that Mr. Irani's case that he's going to return to India in March 2020. There was no cross-examination on that point. I would have looked into the immigration rules and not just taken what he says as his note and cross-examined on the basis of those facts, not just the opinion, but the facts of what the rules for emigration to other
I
countries.
thought the judge had accepted that he was, in all probability, would have to leave to go back to India.
The judge did, but he took it into account in his 50%. That's one of the. He says he has to discuss paragraph 47. He says he has to take into account the chance of higher earnings in India or in other countries.
Yes. So I'm sorry. I thought you were making the point there ought to have been some cross-examination going back to India. That he shouldn't simply been accepted that he would. But the judge accepted that he would be going back to India.
He said on the he does on the balance of probabilities, but then he goes to take it into account in his 50% deduction, which is why it remains relevant, because it also goes to the issue of residual earning capacity.
No, exactly. That's what we're talking about.
Yes.
What was his likely earnings going to be?
Yes.
When he returned to India.
If the my lords, yes. Well, if that's the approach that ought to have been taken, then the 50% discount, which takes into the possibility of going to other countries, ought not to have, the proportion of it which took into going to other countries ought not to have been taken into account. If the judge made it as a finding of fact that he was going to return to India, which you're right, my lords, he does say he probably will return to India. My lords, may I turn, please, to this point? It's a point which I've made a number of times, which is about the reason behind the principle, and to take you to the case of Mohammed Sait and the General Medical Council, and it's a case of Mr. Justice Mostyn.
Yes.
It's a case where it's a consultant orthopaedic surgeon who is subject to GMC proceedings as a result of 2 complaints. The issue in the case was whether Mr. Sait's conduct had been sexually motivated, as the tribunal had found, despite a lack of cross-examination on the point. My lords, if we look at paragraphs 41 to 46, the learned judge describes the issue in Brown and Dunn as being a rule against the anti-ambush principle, which he describes as being made obsolete in paragraph 46 by the introduction of pleadings and skeleton arguments. He says at paragraphs, the principle which he talks about emerges at paragraph 48. I accept, of course, that the key allegation here, sexual motivation, is not directly comparable here with the residual earning capacity, but it is nevertheless the key part of the case, or a key part of the case. It amounts to about 2/3 of the value of the claim or more, the loss of earnings. And the reason
That sexual motivation is a matter of fact, isn't it? So the witness himself, I assume in this case, I haven't read it,
Yeah.
presumably the witness himself was saying, what I did was not sexually motivated.
Yes.
That's a matter which you'd have to cross-examine him on, because that's the central allegation. It's a question of fact, and it's a question of his belief, of his honesty in making that statement, his honesty in relation to that question of fact.
Yes.
So I'm just querying, I'm sorry to be banging on about the same point, I'm just querying the analogy,
Yes.
you know, is it really sufficiently analogous?
Well, can I invite my lords to read paragraph 49 and 50, and I'll make my submission on the points before moving, and then move on, my lords.
That seems to be where the issue is the witness telling the truth.
The words used by Sir Matthew Hale were the questioning of a witness beats and bolts out the truth much better than when the witness only delivers a formal series of knowledge without being interrogated. My lord, if the purpose in cross-examination is to ensure the best method for ensuring the right answer is reached, then cross-examination is the safeguard to ensure justice is done. It's a procedural requirement of justice. That, my lords, is why I submit the evidence of Mr. Irani have been challenged in this case. And if we look, my lords, at paragraph 53, Mr. Justice Mostyn says that the necessity, and I surmise here for the sake of time, Mr. Justice Mostyn says that the necessity to put the allegation relates to whether it's a serious allegation, and if it crosses that threshold, then it should be fully and squarely put. And I agree, my lords. And I say that this was a serious matter. I hear what my lords say about it being a matter of opinion rather than fact, but if the issue here is to try and get to the right answer, and this forms a major part of Mr. Irani's case, then it was still incumbent to challenge him on that part of his case, the part of his case which formed 2/3 of his of the value of the claim. My lords, can I at this point take you to the evidence, because there's been some discussion about it, but it's necessary, I think, just to see what it is briefly, and I don't intend to take too long over this. May I ask you, my lords, to look at page 25 of the supplementary bundle, and this is Mr. Irani's witness statement dated the 22nd of August 2017. It's paragraph 140 that I would invite my lords to consider.
So it's page
25 of the supplementary bundle, my lord. He did make the point, Mr. Irani did give the evidence that he would not be able to find a suitable job for his qualifications in India, and he did give the evidence that he would have to have taken a significant salary cut.
And that was the foundation of his belief in paragraph 141. He was suffering significant loss.
Yes. Yes, my lord. If one turns to page 40, that is the final page of the schedule of loss, which is personally signed by Mr. Irani with the necessary statement of truth attached to it.
Yes.
And if one turns back to page 36, one can see his case, which he's attested to being a true case, at page, on residual earning capacity, at page 36. again, setting out the point exactly as I've already set out, that what his residual earning capacity would have been. My Lords, if we turn on to page 43, this is Mr. Irani's witness statement of the 5th of March 2018, where he confirms the answers given in his appendices are his answers and incorporates them into his evidence. And my Lords, if we turn to page 45, there's an email from his solicitor, Miss Mason, to the defendant's solicitor, Miss Edwards. Page 45, 19th of September. I'm going to take you forward again, my Lord, to page 49. Where there is a question which is asked about whether Mr. Irani would be able to obtain job and pay in India, whether he has evidence to support what he's saying, and he says he'll provide this evidence. And then if we turn to 53, this is the relevant email where he, via his solicitor, provides the email. It's the email dated the 7th of February 2018. May I invite my Lords to read this email? My Lords, I don't ask you to consider the...
Was this exhibited to his witness statement?
It was, my Lord, yes. It's exhibited as KI 3 to the witness statement of 5th of March 2018.
Can I just understand, Mr. Swoboda, what is it you say Mr. Irani lost by not being cross-examined, for example, about the nature and extent of an automotive industry in India? What would he have been able to do which he hadn't put in his evidence, but which you say would have emerged in cross-examination?
Well, it's not a question of what would have emerged in cross-examination. I'm not saying he didn't have the opportunity to build on his evidence. He didn't have the opportunity to indicate whether he accepted or rejected a proposition put to him. I'm not saying that the judge was obliged to accept his answers, of course, but the judge should have heard his answers before coming to a decision, because it's my submission that this is a rule of procedural fairness. I also say that because there was no questions asked, I, as his counsel, lost the opportunity to re-examination to avoid misunderstandings and ensure the full evidential picture was put before the court. Perhaps it would be helpful for me to deal with this point now, especially since you've just read the email to which this relates. My Lord, if we look at paragraph, there was a substantive injustice. He's lost something of real value by the fact that the case wasn't put. If we look at paragraph 46 on page 203, which is the learned judge's judgment at paragraph 46. The learned judge says that he says that the evidence before him didn't provide a proper basis on which to make to make out the case that was put before him. And he says the point is well made in an email from Mr. Irani's solicitor dated the 7th of February 2018 in closing job advertisements, when she says, and he quotes, "My Lords, if you still have the email open, we can see that the learned judge, when quoting from the email, in fact makes a mistake because he omits the words "as he suspected." My Lords, it's highly likely that what Mr. Irani is talking about in this email is not that he's done the wrong search on the site, which is the conclusion the learned judge comes to, but that there was a lack of availability of jobs which met his qualifications in India. That is what he said in his written evidence at paragraph 140, the paragraph I've already taken to you. And indeed, that's what he said in his oral evidence. In passing, the page reference, and this is one of the contentious documents, my Lord, is 74D of the transcript of Mr. Irani's evidence.
You're
Yes.
making a point I want to make sure I understand.
Yes, my Lord.
So the judge has obviously looked at the email,
Yes.
appreciates that the matters in the email are what are being relied upon. He appreciates that, and he's taking it into account.
What the judge says is the point is well made, and what he means by that is that the evidence doesn't provide a proper basis. And he's saying it doesn't provide a proper basis because what's said in the email is that none of the jobs make use of the combined qualifications. In fact, they're not even close. And what he meant by that was that the wrong search had been undertaken, not, as was the case, that in fact there aren't jobs in India to meet Mr. Irani's qualifications. That's also consistent with what he says in paragraph 45, my Lord.
That's what cross-examination has got to do with this. This is the judge, rightly or wrongly, forming a view about the meaning of the letter, what's being said in the letter. And cross-examination, nobody can look into the mind of the judge, I suppose, in the course of the case. But this seems to be a different criticism, not about cross-examination. It seems to be the criticism of the judge's, you say, misunderstanding of the evidence. But that's a different point.
Well, my Lord, I say that it relates for this reason, that because the issue was never brought to the forefront of the judge's mind, because there was never any challenge. It was never forensically examined. It was, a mistake was made, I say, for the very reason that that I based my second ground of appeal on, that there was no challenge to evidence when there ought to have been. I agree, my Lord, that let me put it in this way: the judge, and this is how he deals with the matter. In my submission, he dismisses the evidential value of the Monster India job searches, the 85 pages of job searches, which are behind the email, as well as the other evidence, not on the basis of a right search but not being undertaken, but in fact on a misunderstanding. And I say that misunderstanding simply wouldn't have occurred had he been challenged and had there been the opportunity for re-examination. And that brings into focus the very purpose of the rule. It's to get to the right answer. It's to ensure that justice is done. And the right answer was not got to here, not because of anything other than the fact that there was no challenge on the point, and therefore, in the crucible of cross-examination, there was no consideration of the issue. He was liable to make a mistake exactly because there was never any challenge on this point, and that's unfortunately what the learned judge did.
I don't understand, but what is the mistake exactly you're saying the judge has made? I mean, to me
Yes.
at the moment, what all the judge is saying is, well, if none of the jobs on the market use the combined qualifications, how is that going to help me?
Indeed, and I agree that he says that, but he misses the point that that's because there are no jobs in India which meet the combined qualifications. That's why the words "as he suspected" in the email are so crucial, because it's as Mr. Irani suspected, there are no jobs in India to meet his niche qualifications.
Well, that's an assertion.
But by me, my lord.
Well, by the claimant or by you. I mean, the judge didn't have to accept that premise.
No, he didn't have to accept that premise, but to reject it, he ought to have heard it. There ought to have been challenge on the point, because otherwise there's exactly the type of mistake or error can occur which has in fact occurred. If one considers it in this light, the learned judge finds at paragraph 21 that Mr. Irani is an honest and truthful witness. We know as a fact that Mr. Irani in paragraph 140 of the witness statement from August 2017 says that there aren't jobs in India to match his qualifications. And then the email, which on the most obvious interpretation of it suggests that there aren't jobs in India to match his qualifications, the learned judge comes to a contrary conclusion, which he can only have done because of a misinterpretation, because there wasn't the necessary analysis of the issue there should have been. My lords, it is, I say, impossible to know what the judge would have concluded had he not made this error, but there's no need to speculate, because it's not an issue that it was open to the learned judge to reject Mr. Irani's evidence precisely to avoid this type of error.
Can I just understand that? Are you submitting it was not open to the judge
Yes.
to come to any conclusion other than that in the whole of India that there is no job matching Mr. Irani's qualifications?
No, I'm not. That's not my submission, my lord. My submission is that he wasn't entitled to depart from Mr. Irani's evidence of paragraph 140.
Well, can I just take you back to something my lord the Master of the Rolls asked you earlier? Is a defendant entitled, or in your submission not entitled, to look at the evidence adduced by a claimant, conclude it is insufficient for the claimant to prove his case, and simply deal with it as a matter of submission?
Yes. Well, let me deal with the point head on.
Yes.
My principal submission that tactical reasons for not cross-examining on a subject where a witness provides evidence when that evidence is a major part of the case is not acceptable, and where it's not fanciful account that's being given.
No, I think I can't have made myself clear, Mr. Swoboda. I'm not asking about tactics.
Yes.
A claimant puts forward evidence.
Yes.
The defendant, having considered that evidence, says, well, he's never going to succeed with that evidence, So I'll leave the evidence where it lies and I'll make my submissions. You seem to be suggesting that's improper in some way.
Well, my lords, I do say that if it's a part of his case, a serious part of his case, and he's given evidence on it, then he should be challenged. I'm not saying that, as my learned friend will no doubt say, that he should be given the opportunity to expand and build upon his evidence. Obviously, the skill of the cross-examiner is to ask closed and tight questions, but there should be some challenge to his case.
Thank you.
If there was anything else, then what I would submit is the purpose of the rule, to beat and bolt out the truth, and the best method for doing that is cross-examination, then that is lost.
Yes, I think the only point I was making on 46, I've gone back to the grounds of the appeal.
Yes.
It sounds to me as though the point you're making on paragraph 46 of the judgment is the judge misunderstood the evidence.
Yes.
Whereas your point in paragraph 4, in your grounds of appeal,
Yes.
is he was bound to accept the evidence.
Yes.
So that's a slightly different, I think it's a slightly different point you're making there, in the absence of cross-examination.
Yes.
But this is a slightly different point.
It is a different point.
He misunderstood the evidence.
Yes. But I say it's relevant to my ground of appeal because it shows that there is substantive injustice if the rule is not followed. Substantive injustice in this case, because that would mean that the misunderstanding can stand. I'm grateful, my lord. My lords, at the very least, the judge ought to have given reasons as to why Mr. Irani's argument on this issue was rejected. It was raised with the learned judge in the course of submissions, and for the purposes of your note, it's the supplementary bundle 239G 241F, where I raised with the learned judge that there had been no cross-examination, and I submitted that it was equivalent to calling Mr. Irani a malingerer and not putting it to him. So the equivalent in submissions of saying he's a malingerer and not putting it to him. The learned judge didn't give any reasons as to why he rejected the argument. And my lords, I've included in the Claimant's Authorities bundle the case of Symmetra and Global and Icon Finance Limited, which is a case from this court, my lord, differently constituted, from this year at tab 12 and paragraph. There's a summary of the need to give reasons. From paragraph 39, which is at page 200, to paragraph 47 at 202, and my lords, a neat summary of the law was provided by this court, differently constituted at paragraph 46, which is at page 202.
Should we read that?
My lords,
Which would you like us to read, please?
paragraph 46. My lord, the simple point is this. Mr. Irani ought to be able to know why his case, the submissions on this issue were rejected, and we don't know why. It's impossible for this court to guess why, because there was no reasons given by the learned judge in respect of this argument. He did record, it's right to note that the learned judge did record in his judgment that I had raised this argument, but he didn't go on to give reasons as to why he rejected it, which we know he must have done. That's the only conclusion which is consistent with the findings he made.
So you recognised it in which paragraph?
I think it's paragraph 42. My lords, if you... yes, it's paragraph 42. Mr. Swinburne submits that there's no reason why this evidence should not be accepted in the absence of challenge. My Lords, let me say the effect of the second ground of appeal. If you're with me, I've put the figure in my in the written submissions that it would entitle the claimant to the full future loss of earnings calculation. I know my learned friend contends that that would be unfair to Mr. Duchon because that's more than I contended for at trial, and I can see the force of that argument, and I can see that if you're with me on the second ground of appeal, then I should be limited to the amount that I submitted to the judge at trial, which is a 5 to 10% discount. So instead of, to take the 10% figure, instead of the 1,147,410, which was the multiplier and multiplicand calculation, with a 10% discount, which would reflect my submissions, the figure would be 1,032,669 rather than the 180,000 awarded by
So
the 32,669. My Lord, for the sake of absolute clarity, if you're with me on the first ground but not the second ground, the figure would, for the entire claim rather than just the future loss of earnings, would change to 800,393. And again, the figure that I gave you a moment ago reflects the future loss of earnings, not the entire claim. But for the entire claim, if you're with me on the second ground, or indeed the first and the second ground, the figure would change to 1,259,256.
Sorry, can you give me these figures again? If you succeed on the first ground only,
Yes.
what's the figure?
800,393.
£839,000.
No, 800 at £393.
803.
Sorry, my lords, I should have made that.
I think it was 839,000.
I
If
apologise.
you succeed on your first ground,
Yes.
what will be what?
What would be the total compensation due?
Yes.
It would be 800,393.
I see. 8 yes, got that now.
Apologise, my lords.
And then if you succeed on both 1 and 2, it's 1,259,256.
Correct.
Yes. Yes.
1 million, you could give us a figure.
1,259,256 pounds. My lords, unless I can be any further assistance.
Thank you very much indeed, Mr. Swallow. Yes.
Before I rise to my feet to begin my submissions, would it find favour if I were to request a very short natural break?
Yes, of course.
Thank you very much.
So, and I also mentioned before, since there are only the two of you here, if you want to move forward, it's entirely up to you, or you maybe feel settled where you are, but you're certainly welcome to use the front row if you want to.
Very gracious, man.
Not just yet, Mr. The claimant is just popped a little bit. I'll be back in a moment.
Rise.
Yes.
I'm grateful, my lords. I oppose the claimant's appeal, and it is respectfully submitted that the appeal ought to be dismissed. May I deal with the grounds of appeal in the order that they were made? And firstly, my lord, to deal with the fact that the judge made a Blamire Award and a Smith and Manchester Award versus the multiplicand approach. My lords, the judge expressly had regard to the decision of this court in Bullock and Atlas Ward structures. He expressly recognised the limits of his discretion at paragraph 44 of the judgment, which, my lords, you have been taken to already at page 203. There is ample authority, even in the case of Nower, as set out by my learned friend, which you will find in tab 1 of the Claimant's Authorities Bundle at page 15, where the case of Wells and Wells is cited in paragraph 16. In that case, my lords, Lord Lloyd of Berwick said this: I do not suggest that a judge should be a slave to the tables. There may well be special factors in particular cases, but the table should now be regarded as the starting point rather than a check. A judge, of course, should be slow to depart from the relevant actual multiplier on impressionistic grounds, or by reference to a spread of multipliers, especially when multipliers were fixed before the actuarial tables were widely used. In Nower, of course, my lords, different issues arose in relation to a fatal accidents claim. But it is worth noting, my lords, that the commentary to the Ogden tables and the introduction continued ever since the 6th edition to recognise that in some cases the judge must have a residual discretion to make lump sum awards. That, my lords, is what the judge had regard to quite properly in this case. My lords, the judge was aware of the limitations upon his discretion and adequately reasoned them. He was directed to the decision in Ward and Allies and Morrison Architects, which, my lord, is at page 26 of the claimant's appeal. My lords, this was a case which involved a young claimant, as with this case, who, as with this case, had a first-class honours degree, as Mr. Irani has, his being from Pune University in India. And the principal dispute on appeal, my lords, was the basis on which the judge awarded damages for future loss of earnings. Should it have been the broad brush Blamire approach, as the judge in fact held, or should it have been on the conventional multiplier multiplicand approach? The judge, and I can invite you to paragraph 12 of the judgment, made his awards under the various heads of damage sought. And as Lord Justice Atkins, sitting in this court, said, on the question of future earnings, he concluded that he did not have sufficient evidence as to what the appellant had lost, or what she was likely to earn in the future, or the time during which she needed to be compensated for the future loss of earnings. So, as Lord Justice Atkins went on at paragraph 20 of the judgment, page 31, my lords, to say this: it's common ground that the multiplicand methodology and the tables and guidance in the current edition of Ogden should normally be applied when making an award for damages for future loss of earnings.
So 31.
Yes, page 31,
Page
paragraph 20. It begins in
Paragraph 20. It is, I've got paragraph 20, yes. Thank you.
when making an award for damages for future loss of earnings, unless the judge really has no alternative. My submission is very simple. This really was a case where the judge had really no alternative. In order to carry out a conventional exercise, a judge has to deal with two aspects before a multiplicand figure can be calculated. First, he has to make findings on the likely pattern of the claimant's future earnings if she or he had not been injured. The judge in this case clearly felt able, on the evidence provided, to do that. Secondly, the judge has to make findings on the likely pattern of the claimant's future earnings, given the fact that she has now been injured as a result of the defendant's negligence. As Lord Justice Steen pointed out in the Blamire case itself, in respect of both issues, the burden is on the claimant. This means that in this case, it was for the appellant to satisfy the trial judge on the balance of probabilities. First, what career path it was likely she would have taken. And so she would have earned over the period for which a claim for future loss of earnings could be made, which period would itself be matter of proof on the balance of probabilities. This exercise would involve establishing both the type of work the appellant would have undertaken, had there been no accident, and also the level of remuneration that she would have obtained from it. Secondly, the appellant would have to satisfy the trial judge on what work she was going to be able to undertake following the accident, what would have been less remunerative than the work that she would have undertaken had there been no accident, and if so, by how much. The judge in this particular case was also not satisfied that the appellant had proved that she would actually suffer a loss of earnings as a result of the accident. The challenge, as in this case, to the lump sum award which was made in Ward and Allies was that the judge should have adopted the multiplicand approach. This court upheld the approach that the learned judge took in that case, and I invite a parallel to be drawn between this case and that one. Clearly, the judge in this case felt unable, on the evidence adduced by the claimant, for which there was a burden upon him, to be satisfied as to what the second part of the multiplicand should be, notwithstanding a bare assertion and beliefs by Mr. Irani that he would literally earn almost nothing, as according to his evidence, which in my submission was mere hyperbole and belief.
Well, you're going to ground two now.
Yes, I am. But in relation to this, I digress. There were a number of imponderables which also made a multiplicand approach inappropriate. For example, the chance that the claimant would be successful in seeking permanent immigration to another country other than the UK. He had, for example, provided no evidence for why Canada wouldn't be an option open to him, which was something that the judge expressly referred to during submissions, though not in his judgment. But he said in his judgment, page 203 of the core bundle, paragraph 45, my lords. Whilst I have accepted that Mr. Irani will probably, not definitely, but probably return to India, it's by no means certain. He's a highly educated man with specialist qualifications. He may choose to make his future in any number of Commonwealth other countries, however difficult that may prove to be. It's worth noting, of course, that in this judgment, which was not argued against by Mr. Sabota, that the judge awarded the claimant £15,000 for legal advice about seeking immigration elsewhere. And he had not yet obtained that appropriate advice and accepted the award. So it is quite clear, in my respectful submission, on the claimant's acceptance of the award, that he was yet to mitigate his loss fully. That was one imponderable. The other imponderables were set out in the counter-schedule of loss, my lord, which we submitted for the purposes of the trial, which, my lords, you will find in the supplemental bundle at page 163, paragraph 36 of my counter-schedule.
163?
163, supplemental bundle.
Yes.
It's also potentially relevant to the second ground, my lord, because we gave the claimant 3 warnings that the evidence upon which he was adducing was insufficient to prove his case. The first you had already seen in the email from my instructing solicitor, Julie Park, who sits behind me, to the claimant's instructing solicitor, posing questions. It's hard to see how that is not an unfair, how that is a unfair approach.
What's the date of the email? Have you got the date and the reference?
It's give me a moment. It was 19th of December was the reply.
It's page 53, 7th of February 2018.
Yes, thank you. 7th February 18, you're quite right. Now, that was the email which came back. The email which was sent, I think the date is cut off on it, my lord. But it's
Page 49.
It's page 49 in the bundle, but the date is cut off.
No, the date is page 49. It's 6th of October 2017.
Thank you.
6th of October.
And it was replied to on the 19th of December 2017, my lord. Page 4.
Are we still on the one, or you said there were three separate?
Yes.
occasions?
The first was that this was the first one, the email. The second is my skeleton argument. Sorry, my counter schedule of loss. Page 163. Paragraph 36, where we challenged loss of earnings in the future. 1, there was inadequate evidence of any loss of earnings. 2, there was no expert evidence. This was practically tantamount to inviting the claimant to produce an expert evidence on this. My learned friend speaks of shadow reports, but he hadn't even provided any evidence or expert evidence about this crucial issue of loss of earnings in India. So, if this didn't prompt the claimant to get his house in order in relation to establishing a loss, it seems to lie ill in the mouth of the claimant to suggest that his case could have effectively been improved if we cross-examined on it when he didn't have the evidence to establish his loss in the first place.
Going to the imponderables, you mentioned going to a country other than India. paragraph 36 mentions growth in India. What are our imponderables?
Well, one of them, the other imponderables are for how long, of course, that he is going to suffer a shortage in salary. And any search he took of the job market would be simply that, a snapshot in time, even if it were true. So in essence, what we don't know is how long he would have suffered the shortfall in salary for before being able to change roles or for other matters to take place, such as retraining. One matter I did cross-examine him on, where I sensed there was a duty to do so, was there was a growth, was the fact that India was changing. India, and we had expressly pleaded in the counter schedule that India was a country on the move with a growth rate of around 7.3% compared to the United Kingdom's very slow growth rate. And we actually said it is not admitted that in the future India will be inferior as a venue for employment and salaries as compared to the UK. India has an economic growth rate far more than that of the UK, presently 7.2% as of January 2018, compared to 0.2% for the UK in January 2018. So we were pointing out, even in the counter schedule, as early as that you really had to provide some evidence to the claimant of what was his likely future pattern of earnings, not just a snapshot in time. And for that, what we were hinting at, without proving the claimant's case for him, but out of fairness, was produce some evidence. Plus, the claimant made late applications to rely on further witness statements. As you know, there are at least four witness statements that he relied upon. The last of those was produced, my lords, in April 2018. We fully expected that there would be better evidence than there was for him to prove such a major head of law. If, of course, I'm right on my grounds of appeal, we never get to this point in the first place. It may be the claimant didn't expect to get there, but whatever it was, he did get there, and then he found that he really didn't have the evidence. Now, in relation to that, there was inadequate evidence of future earning capacity is my headline point, my lords. So we did cross-examine him on the opportunities in India if the claimant would be compelled to go back there would increase. We did cross-examine him on that. But that led the judge, and this is at paragraph 19.2 of my skeleton argument, which is core bundle page 57, my lords. I do not accept the assertions made in the schedule that in India there will be little opportunity for career progression, or that his injuries will stop him from gaining promotion, or that he will continue to earn £10,000 per annum until retirement. Now, so, my lords, the judge was clearly not satisfied as to the multiplicand in time and amount. So, as I said in the counter schedule, paragraph 36, the defendant was right. There was inadequate evidence of any loss of earnings. This was a case crying out for one of those rare cases where expert evidence would have been allowed by the master in my submission, had it been asked. But it would have been fairness and equality to have been asked for on both sides. There was no such evidence.
You said there were three occasions in which you said the evidence was insufficient.
The third arose when the judge interrupted in relation to the point which I have just made, my lords. He inquired as to the purpose of the cross-examination on India's growth rate. And I said to the judge, this is in dispute. And we dispute future earnings. So if we had not made it clear enough that this evidence was challenged, this was the third option. That is in the submissions transcript, which is a contentious document, but I do accept that it probably does assist on this.
Can you just, under your first one, I didn't take down the page numbers for the reply email. So the email of the email at page 53 is the one which Mr. refers to.
Page 45, my lord.
So your reply is page 45.
Page 45 to 49. And it's a reply dated 19th December 2017, 8:49 AM, supplemental bundle, page 45.
So this is. The answers that are given here, I'm just trying to work who this is for. At page 45, there's an email in response to which email?
That is in response to the October email, my lord, sent by Julie Park at page 50 of the bundle.
Page 50. Right, so
Question-
50 is from your client.
Yes.
Right, okay.
And it begins, Dear Deborah, carbon copy to Amy Edwards, who also sits behind me. Your client states he would not be able to obtain an equivalent job pay in India. Does he have any evidence of this? A fair, open question which invited the claimant to produce further evidence on the point.
What's the date of this?
It was 16th October.
6th of October.
6th of October.
It's at the very bottom of page 49, my lord.
I don't know why it's got off.
October.
Sorry.
Oh, I got you.
Ah, yes, it is. No, it's there. 6th October 17, bottom of page 49.
So I'm just seeing how this chain moves. So this is October. Right, so we end up, is this right? We end up with this letter of the 19th of December.
Yeah.
No, you don't know. So it goes on.
February. And then it goes on to February, where the ultimate conclusion at page 53, my lords, of the supplemental bundle. And this was the letter which the learned judge had regard to, which my learned friend says he must have misunderstood. Now, when one reads that letter, my lords, it actually says, it may not even be intimating that this is a permanent role, or a permanent change, because it says this: the jobs which are advertised, and for the majority it means that he would have to perform a major role change, or some sort of managerial role. He would need to take a massive salary cut if he were to apply, and to get through to any of the advertised roles. Now, it doesn't even make an assertion that this is permanent. It does indicate, of course, that Mr. Irani is capable of undertaking change, which was a point perhaps not seized upon by the learned trial judge, but which is there to be seen, which he must have taken into account.
Sorry, can you just repeat that submission?
Yes, it doesn't indicate any permanence of the salary cut. It indicates a salary cut if he's got to change roles and apply to effectively a different track of employment. So, what the judge couldn't be satisfied of here, even if for a moment a learned friend's right that he could have been satisfied in relation to the multiplicand at an instant, he had no evidence at all, because the claimant had not adduced any, of the career path that the claimant would take. This was more than mere uncertainties as to the future. There was a devastating lack of evidence as to the future.
Well, right, I'm going to take you out of your order, but at some point I would like you to address the central point made by Mr. Swoboda on the ground one aspect, which is at paragraph 44, where he says the judge made an error of law. 44 read with 47, we read with 47, which is that the judge made an error of law in accepting that it was practicable to apply the multiplying approach, but that he could deviate from it because there was nevertheless a real risk it would create an obviously unreal result.
Well, my lords, I submit that the learned judge what he said was this: Mr. Medan submits there are too many uncertainties for me to approach the claim from a future loss of earnings on a multiplicand approach. It invites me to make a Smith and Manchester Award and a Blamire Award, whilst as a matter of principle I accept that the Blamire approach should only be used where other methodology is not practicable. It seems to me that, to use His Honour Judge Hughes QC's words in Kennedy and London Ambulance Services, there is a real risk it will create an obviously unreal result. My lords, the judgment has to be read as a whole. And when one reads the judgment as a whole, rather than in isolation, the judge was clearly quite not satisfied that it was practicable to make any multiplicand award, because he just could not be satisfied, due to lack of evidence, that what the multiplicand for India for the remainder of the life was. So he must have been, in that regard, talking about, or he must have been referring to the Smith or disability rather than the fact of it being him being able to make a multiplicand award at all. Because there was two elements he had to be satisfied of. The multiplicand approach and whether he should make a Smith award. He in fact, at my invitation, made both a Smith award and a Blamire award. So in these circumstances, he was entitled to reach the view that firstly, the multiplicand approach is not one he could take because he lacked a vital part or element of the information upon which to make any award. Secondly, what he must have meant was, if it was practicable to have made an award on that basis, there were in any event too many imponderables for another reason. And a Smith award was appropriate along with a Blamire for these reasons. And that was perfectly within his discretion to decide. What my learned friend has to show is that that was so unreasonable that no reasonable judge would have come to that conclusion. So what we had in
I'm not sure that's. Sorry, I don't think that can be right.
well, it's the element of discretion.
Because is the judge simply exercising a discretion? This isn't like a case management decision discretion. You've got to. The law requires you, does it not, to apply the to apply the multiplicand approach, save where it's not practicable. So that's not a discretion. The judge has to form a view of that.
I suppose it's a residual course, if we put it that way. One can take that course if one forms the view that there is insufficient evidence to reach or to apply a multiplicand approach. Now, in reaching that decision, the assessment of the evidence, my lords, and the weight to give it is a matter of discretion for the trial judge, and one where it was best able to weigh up the evidence the way it had been given. So it's a mixed element. I accept that.
Well, I don't know. It wouldn't be right. Anyway, can we start from where there's a see if there's any community of agreement. Do you accept the proposition that in a case like this, the judge should make an award on the multiplicand approach, unless he forms the view on a proper basis that it's not reasonably practical to do so?
Or no real alternative.
No real alternative.
Yes.
You accept that? So
That
there's
is
a common
That's
starting
the way
point.
I understand it, my lord.
Right. So that's the starting
Yeah.
point. You say, and I totally understand this, you say that, he formed the view on proper grounds
Yes.
that it wasn't.
Yes.
It wasn't possible practically to apply the multiplicand because of the uncertainties.
Yes.
That is clear enough. But what Mr. Swoboda is saying is that the judge appears to be saying in paragraph 44, even if it is practicable, nonetheless, there might still be a real risk that it would create an unreal result.
Yes,
I'm trying to understand what you say the judge means in that.
I submit that the judge is clearly taking an alternative. If this court found that it was practicable, he's taking a further alternative, saying this is another reason why I couldn't. What he's really trying to say in that paragraph, I respectfully submit, is, well, if it was practicable, then I would still not have made an award because there were too many imponderables. But his starting point was that he couldn't really make an award because there was just insufficient evidence. And that fits with the level of evidence which the claimant had produced.
So what you're saying, I think you're saying this is, the judge is saying, well, it's one thing as to what is practicable.
Yes.
In the sense you can look at the schedule or tables, and you can make an assessment of the multiplicand, but because of the uncertainties, it produces, that mechanical exercise produces an unreal or potentially unreal situation. Is that what you're saying?
Well,
The
yes.
judge is meaning that
Yeah.
there's a kind of a mechanistic approach that you can
Yes.
apply.
What he was saying is, in this case, first of all, he was not satisfied, it's quite clear, on the multiplicand, and he expressly makes that clear elsewhere. So he expressly rejected the evidence, which was for him, within his discretion, to reject the evidence on multiplicand, because the weight to attach that evidence was for the trial judge, and he was respectfully correct. Certainly not wrong to do so. Two, he's then entitled to say, well, in theory, a multiplicand approach might have been practicable. If it was practicable, I'm not making that approach because there's too many imponderables. But he's entitled to give a judgment effectively in the alternative, providing a number of reasons why he couldn't have made an award on the multiplicand.
What do you say about 47, where he says if I had done it, I would have made a 50% discount?
Yes, well, clearly, firstly, it's obiter. It wasn't strictly necessary for the decision. He'd already reached the decision. I suspect he's providing a third reason why, if he had been able to make a multiplicand approach, he would have discounted for some of the improbables which were identified in that paragraph. And there was only one, the chance that he may obtain better employment in India or elsewhere. So better paid employment in India, or chance that he would move elsewhere. But what he couldn't set out in the first place was what his earnings in India would be over the course of his lifetime. And this was more than mere future uncertainty. This was a complete lack of evidence, of proper or reliable evidence, as I put it in the counter schedule, in relation to the multiplication.
Is that a convenient moment to stop? Now, how much more have you got to say?
Only really in relation to the ground tube.
And you've covered part of that already.
So maybe another 30 minutes.
Thank you very much to it.
Surprise.